Hello, everyone, and welcome to our presentation today on the Architectural Standard of Care and Managing Project Risk. All the AIA architects and associate members will get one learning unit. And I want to also let you know we're recording this session and we'll be posting it on our YouTube channel. So thank you to our monthly sponsor, Carnell Collective. We're very grateful for our sponsor's support for the chapter. And now I'd like to introduce our presenters today, attorney Michael McDonald and his partner, Stephen Litchfield. They're joining us from Newport Beach. If you have any questions during the presentation, you're welcome to post them in the chat box, or you can put up your hand and they'll be addressed at the end. So over to Michael and Stephen. Thank you.
Thank you, Tara. Good afternoon, everybody, and thank you for jumping on this lunchtime seminar with us. We know you guys are very busy, so we'll try and make this as entertaining and informative as we possibly can. Just real quick, let me introduce myself. My name is Michael McDonald. I'm a partner here at Litchfield Law down in Newport Beach. Our practice specializes in representing design professionals, architects, engineers throughout the state of California. So I'm here today along with my partner, Steve Litchfield.
Yeah, thank you for having us. It's especially nice for me. I'm born and raised in Santa Barbara, graduated from San Marcos High, so it's good to be back with AIA Santa Barbara. And yeah, like Mike said, our practice is specializing representing design professionals. We'd like this to be as interactive as possible, so feel free to ask questions, and we're happy to stay after to talk things over if any questions come up. So without further ado, we will jump into it.
Okay, so the title of today's presentation is going to be the Architectural Standard of Care and Managing Project Risk. So hopefully, after today's seminar, we will have accomplished the following objectives. So one is just defining and understanding what the architectural standard of care is, something that is going to be inherent in almost every project and certainly every contract. So we're going to talk a little bit about that. The next one is learn the standard contractual terms that every architect should know. Again, these are issues that appear time and again, and are issues that we get lots of questions on. So we're going to help you navigate certain issues that arise in the contract setting and allow you to make more informed decisions in your practice. The next one is using these concepts to help you better mitigate risk when not only negotiating the contract, but also upon execution. And then last but not least, we're going to go over some of the common red flags that arise time and again during the project, and we'll give you some strategies to help address them to help better protect yourself. Okay, so jumping right into it. This may seem pretty basic, but just so we all have an understanding here, what is negligence? And this goes in with the standard of care. Technically, the legal definition of negligence is the failure to use reasonable care to prevent harm to oneself or to others. Harm can be economic harm, cost overruns, construction delays, can also be personal injury. Hey, you designed this, stairwell without the proper railing or a warning, and I was injured as a result. Or it can also be property damage, improper drainage or failure to incorporate below grade waterproofing. That's always a fun one. So that's the definition of negligence, and we're going to see how that plays into the claims part of it.
Sure, and I think that we all have an understanding of this legal term negligence, but it's helpful, I think, to understand exactly how it applies in practice to architects. So up here on the screen, you'll see a California jury instruction. So this is actually what is read to the jury by the judge in a trial. And this says an architect is negligent if he or she fails to use the skill and care that a reasonably careful architect would. And that is an important point because your obligation as a professional is not to be perfect. It's not to be the best architect in the world. It's to do that which a reasonably careful architect would. And that theme is going to come up again and again today. And it's always in the context of the circumstances under which you're delivering the project, including the size and scope, the location, and all those types of things. So this is generally referred to as the standard of care. And if you fall below that standard of care, you're what's called negligent. So, and then down to the second bullet point here, just one interesting point is that the standard of care in a trial or arbitration is defined by expert witnesses. But in California, you also have yourself, the architectural defendant. You help the jury through your testimony understand what the standard of care is. So I've always found that to be kind of an interesting wrinkle. And then sort of dovetailing with that is something that everyone here is probably familiar with. If you're like me and you see a AIA kind of form contract, you feel a little bit warm and fuzzy. And this is the statement in the AIA B101, which is kind of what we want to see in our contracts and actually what the law in California says, essentially the standard of care for an architect is. So you want to see these words that are kind of, we associate with reasonableness. And I would just add one caveat that just because you see an AIA agreement doesn't mean that someone hasn't edited it without telling you. So don't feel too warm and fuzzy. Always make sure that you're taking a look at it to make sure that it hasn't been modified in some way that could be problematic. And then kind of from a risk management perspective, the thing we want to teach you today is you can raise the standard of care that applies to your project through contract. So you need to be diligent in ensuring that you know how that happens. And we're going to run through some of the phrases that you can kind of look for as sort of red flags. But this is the state of California law, kind of similar to what we've been saying. Unless you agree to something else, you're only promising to perform as the reasonable professional would perform. You're not guaranteeing anything, you're not providing any warranties, and you're not essentially providing anything else other than what the reasonable architect would provide. And some contractual terms that can raise the standard of care, and Mike's going to get into this a little bit more on the next slide. But if you see, the word best, state of the art, highest quality, warrants, those are all ways that you can essentially raise the standard of care above that of the ordinary architect.
Okay, so in your practice, when you are negotiating the contract or reviewing proposals, reviewing a contract draft, here's some of the words that you're going to want to look for, both the good and the bad. So we'll first call these the green terms. You want to see words in the standard of care provision: typical, average, standard, reasonable. Those are the words you want to see. And that's all the law requires. If there's one thing we can stress is the law does not require perfection. The law does not require you to guarantee anything. There's no strict liability applied to architects and engineers unless you agree to that. And so with these green terms that you're seeing here, you are helping insulate yourself from any type of claim that you guaranteed or you're strictly liable for any type of issue that arises. So conversely, here's some of the bad terms that you're going to want to try and take out of the agreement, or these are things that red flags should be going up saying, hey, this is an issue here. So things like best, highest, defend, we're going to talk about in a little bit what that means. sole discretion and warranty. Those are bad terms that can be used against you if an issue arises down the road.
And one thing I just wanted to stress here is before we transition to a little case study that we're going to run through, is sort of the why behind all of this and the importance of negligence and the standard of care and what your contract says. As anyone that's been through a professional liability claim knows, so much of that is dependent on your professional liability insurance coverage. So much of what we do in our risk management practice is making sure that our clients don't accidentally misstep in their contract or otherwise and jeopardize that professional liability coverage, because it's there to protect you and your firms. So if you agree to things like, providing the best and perfect design pursuant to the highest standard of care, your insurance company can see that and take the position that you agreed to something beyond what your insurance policy covers. So that's really why we focus on this so much and why this matters so much, because you can inadvertently agree to something, even if it sounds innocuous, that could put your firm essentially without insurance coverage and at risk. And that's kind of the worst case scenario that we work every day to avoid. So with that in mind, we go to a real life example that we have changed the names of the innocent and the guilty, and we have also changed the facts a bit just to make it, but generally the fact pattern is true. So in this example, we're calling the case the City of Irvine versus Architects California. And at issue, we have a mixed use project, we have retail, residential, we have a sports facility, a big project. It's going to mean a lot to the City of Irvine, both in terms of increased tax revenue. It's going to add jobs, it's going to add additional development. There's additional housing and retail that are going to be knock-on effects of this development. So the city is excited about it, the architect's excited about it, and the architect is tasked with shepherding this project through. So we start off, and I always say that if you see a provision like this and your client is asking you to sign this and potentially waive the professional liability insurance that you pay so much to maintain, you should ask why. But this contract provision essentially has all the red flags that you could possibly see. It says city and architect acknowledge and accept the relationship of trust and confidence. And now this is important, and it sounds like something that, sure, you want to have this with your client, right? But actually it's one of the biggest kind of deal breaker risk terms we see in contracts, and I'll explain why at the end of this. Architect agrees to, at all times, exercise its best efforts. There's another one of those red flags. In furthering the interests of the city and designing a first-class state-of-the-art facility. Guaranteed, there's another one, LEED Platinum certified. As we know, that's a dangerous thing to guarantee. Consistent with the highest standard of care in the industry and entirely free of defects. This is exaggerated a little bit. I don't think anyone could come up with something quite this bad. But as we often say, there's never been a perfect set of plans. There's never been a perfect set of calculations. We're all human, we make mistakes. Let's not, in our contract, agree to provide something that's entirely free of defects, because we know that we can't. So starting off on the wrong foot and then getting worse. So during design, some of the revenue projections for the project in terms of what it would generate for the area, those go sideways. Construction costs go up. The city decides to convert from apartments to condominiums. That causes a dispute with its architect. As we know, that can be an issue. A number of other things as well. So the architect does a pretty good job. There's a limited number of errors and omissions, but those errors and omissions do drive the critical path for the project. And then we have COVID-19 hitting in the middle of it, obviously injecting uncertainty and delay into the project. So then there's a lawsuit, and this is an important point here. The architect had been paid $10.2 million in fees on the project. And when the project went a little bit sideways, the owner paused those payments, and the architect had an accounts receivable balance of $256,000. And that decision, without the full knowledge of the architectural firm's management, the decision was made to move forward with a lawsuit to collect that $256 million. As we know, the death taxes and a cross complaint when you sue for fees. So the city counterclaims, and their ask is $52 million. So this firm could have done a better job managing its risk in terms of its accounts receivable, especially when it knew that this project was going sideways. Now we get back to this, that provision we saw at the beginning, the relationship of trust and confidence, free of defect. This goes all the way to a jury, and they find that the architect owed a fiduciary obligation to the city, meaning not just two parties contracting at arm's length, but they actually were supposed to put the city's interests ahead of their own, which is completely unusual. It's uninsurable, but because the language of the contract was so bad, the jury found that the architect had breached that fiduciary duty, and they fell below the standard of care. They didn't design to the highest standard of quality, and then they also caused these consequential damages in the form of loss of anchor tenants, residential sales, free fall. The sports franchise relocates to another city, and that $252,000 fee claim turned into a jury verdict of $52 million that this design firm was forced to deal with. So the kind of takeaways here are, think about your risk management processes in collections. This is obviously an extreme example. Think about how contractual terms can affect, ultimate results and sometimes lead to unintended consequences. And, when in doubt, and we promise to never make these things sales pitches, but we're always available to try to help if you have an issue that comes up that you have a question on. So that's our little case study, and we should be able to, tie in the rest of this to that as we move forward.
All right, so the next issue that we're going to talk about that, sticking with the idea of contract terms that you should be aware of and how to address them. So we just talked about the standard of care and some of the issues associated with that. The next thing we're going to jump into is indemnity and the duty to defend. Many of you already may be familiar with this. This is also a very, almost in every contract that we've seen, this is a big issue. And unfortunately, when there's a claim, this is often the driving force that gets architects and engineers wrapped up in lawsuits that are very difficult to get out of. And we'll explain why here in a minute. So this, just here on this slide, is kind of your vanilla, typical indemnity and defense provision. It says, usually something like, to the fullest extent permitted by law, the vendor, which is going to be the design professional, the architect shall indemnify, defend, and hold harmless the city or the client. And then it will list off all the other people that fall under the definition of a client from and against any and all causes of action, claims, liabilities, obligations, judgments, or damages, including legal attorney's fees and litigation costs that arise out of the architect's performance or architect's failure to perform its obligations under this agreement, except for such losses that arise out of the sole negligence or willful misconduct of the client. So we'll break that down here in a minute, but this is, again, a prototypical duty to defend and indemnify provision. So we'll go next into the actual duty to defend. So according to the biggest, case on point in California regarding the duty to defend, it is a contractual promise to defend another against specified claims that clearly connotes an obligation of active responsibility from the outset for the architect's defense against such claims. So the duty promised is to provide the service of providing a defense on the client's behalf. a duty that necessarily arises as soon as such claims are made against the client and may continue until the time they have been resolved. So what does all that legal jargon mean? It essentially means that if you are an architect under a defense provision is assuming the duty to defend the client against all lawsuits and claims that arise out of the architect's work, unless there are certain exceptions. So it's a very broad obligation, and it's the duty to defend is to provide a legal defense or to reimburse the client for its legal defense and costs. So that's why it's particularly onerous. Another huge issue with the duty to defend is that it's not typically insurable. This is a contractual obligation between the architect and the client. It's not based on negligence. And so these are issues that often are not covered by professional liability insurance. So it's a big issue. And often, you know, if a owner or the client gets wrapped up in a lawsuit, let's say the general contractor is going after the owner for, you know, unpaid fees. Oftentimes, the knee-jerk reaction is just going to be the owner is going to then sue everyone that it contracted with. Oftentimes, that's the architect. And more times than not, there's going to be a defense obligation, and they're going to tender their defense and say, hey, architect, you owe me a defense against this contractor's claim because these claims arise out of your work. It's that broad. And so Steve's going to talk a little bit in a few moments about some of the technical aspects of how the law has changed a little bit that actually help architects in this situation. But just in general, the duty to defend, again, red flag issue. Sometimes it's unavoidable, just due to bargaining leverage. And you know, these are, if you're dealing with a large client, they're going to insist on this. So there are some things you can do to try and, you know, narrow the scope of this, which we'll talk about. But by and large, this is what the duty to defend is and what it requires the architect to do. So the corollary of the duty to defend is also the duty to indemnify, which is a separate duty. And the duty to indemnify is essentially the architect is saying, hey, owner, if you incur losses or expenses as a result of my negligence, I am agreeing to reimburse you for those. So it's kind of the duty to defend arises at the time that the owner tenders its defense to the architect. The duty to indemnify arises down the road once the owner has actually, or the client has actually incurred losses that could be attributed to the architect's scope of work. So that's a distinction between the two. They're separate duties. Again, another red flag issue, oftentimes unavoidable, but at least, you know, you'll be armed with knowledge of kind of what that means. And again, we'll talk about ways to minimize the scope of that obligation.
Yeah, that's a good summary there. And since we have, we're a little bit ahead on time, which is a rarity. So I'd like to just go back to the previous slide for 1 second, because one thing I'm seeing in a lot of contracts recently is this, on the second line here, you have what I call the scope of the indemnities. In other words, who are you agreeing to indemnify under this agreement? This one has elected officials, officers, employees, volunteers, and agents. I'm seeing this in a lot of contracts start to include a broader group of people and entities, and that's a problem. So if you start seeing the two biggest ones to me are contractors and consultants, because if you're suddenly agreeing to indemnify and defend the owner's separate consultants or their general contractor, you know, that is just so unreasonably broad that you're going to have issues. So just as kind of a practice pointer, try to focus in on who you're actually agreeing to indemnify. It should be your client and maybe a limited subset of other people, but just wanted to raise that point. So as Mike mentioned, architects in California did get some good news. So any contract that you've entered into since January 1st, 2018, whether you knew about this or not, whether you did anything or not, you receive the benefit of Civil Code 2782.8. I'm not gonna read it all out loud, but it essentially says that any contract for design professional services, so that's architects, engineers, and land surveyors, that purports to ask a design professional to defend, and we're talking about an upfront duty to defend and pay attorney's fees of the other party, is unenforceable. So essentially, for our purposes, that's how I read that, and that's how I interpret it. I may be biased because I represent architects and engineers, but this is what this says. And anyone that tries to argue differently is going to have to deal with the language of this. So for anyone who knows, negotiated contracts pre-2018 and what we call the Crawford and CH2M Hill era, this defense obligation was a huge issue because it actually said that you could be responsible for paying the other side's attorney's fees, even if you went all the way to a jury verdict and you were found to be not liable, 0% liable, 100% defense verdict. You didn't do anything wrong, but because the word defend showed up in your contract, you had to pay attorney's fees for the other side. So this statute gets rid of that. So it's very important, and we rely on it a lot these days. We can sometimes live with the word defend if we get other concessions in contracts because we have this to fall back on. So it's been kind of a steady progress, I would say, towards this. We got some incremental improvement in 2012, but this adjustment to the statute in 2018 was the big one. And I would just caveat this by saying that if anyone does work with agencies of the state of California, Civil Code 2782.8 does not apply to those contracts. So the legislature was willing to go only so far, and then they carved themselves out of that. And there's still no case law on this, so we don't know exactly the extent of that, but our read on it is that projects at UCSB would probably fall into agencies of the state because the regents are likely within that. So just a quick caveat there. And then also, whenever anything happens in the law, people are going to figure out a way around this. So the owner's attorneys, the developer's attorneys, what we're calling the plaintiff's attorneys here, they see that and they say, okay, we see that, but we're going to reverse the framework. So we're going to say that you immediately defend us, and then if in the end it turns out you weren't negligent, we'll pay you back. Whereas the statute says that we can only be charged for reimbursing the other side for their defense costs in proportion to our fault. This says, yeah, we read that, we understand what that says, but you're gonna have the upfront risk and you're going to pay, and then we'll pay you back if it turns out that we were wrong. This hasn't been tested. There's no case law on this. My personal opinion is that this would be unenforceable and that there would be no upfront duty to defend in a circumstance like this. But there's a lot of bad case law in California on the duty to defend. So an argument can be made the other way. It takes a pretty savvy plaintiff's attorney to get this in there, but I'm seeing it more and more, maybe 1 out of every 20 contracts. So I thought it was at least throwing a slide in so you could kind of understand it and be on the lookout for it. So that's kind of our take on indemnity and the duty to defend. And before we move on, I'll let Mike.
Just real quick, just from a practical standpoint on this, we might say, okay, well, we'll agree to immediately defend you, but hey, if we're not negligent or it far exceeds our proportionate share of fault, then you'll just reimburse us at the end. Practically speaking, that has almost a 0% chance of happening. If there's a lawsuit, there'll always be some type of wrangling or negotiation, and the owner will fight tooth and nail, or the client will fight tooth and nail to get out of any type of reimbursement. So going back to try and collect your money for amounts you paid up front is just not a practical way to handle it. So again, just to the extent these become more and more commonplace. They are bad news and again, huge red flag.
Yeah, and we tend as lawyers to be a little bit cynical. So we don't talk about the positive, which is if you can get indemnity and defense in your favor, you should go for it. Because the owner often can, your client can do things that affect you. And, having an indemnity provision in your favor is a good thing and can give you leverage. Or at least negotiating something what we call mutual indemnity, which means you have an identical provision that runs both directions. That's preferable to a one-way indemnity, and we'll take that any day.
Okay, so then going kind of related to that is, you're negotiating the contract and you're delineating kind of what, or you're defining what your scope of services are. So this is also a big potential hazard for clients who, scope creep is a big issue where, and this happens a lot too, where you're in the residential construction realm where you're dealing with a wealthy, owner, and this is a big custom house, and they want a Rolls Royce but want to pay Chevy prices. Your scope of services is going to be a huge issue. So really, just in general, the key takeaway here is you want to as best you can, you want to be able to specifically identify what your scope of services are. And likewise, if you're not including services under the contract, but you can kind of look ahead and say, hey, these might be issues related to this down the road. You need to, it's good practice to identify what the contract doesn't include. Oftentimes that's just as important. So, for instance here, so architect shall provide 95% construction documents to client for client's review and approval. Approval by client shall be in client's sole discretion. So here's an issue where you're kind of agreeing, you're leaving it open-ended for the client to exercise the sole discretion as to when documents are going to be approved. Well, that's just an invitation for the owner to exercise leverage against you and say, well, I'm not going to pay you. These aren't meeting, my standards, and this isn't what I want. And that leads to more work and, problems down the road. So a better approach is architect shall provide the 95% construction documents to client for client's review and approval, which shall not be unreasonably withheld. Again, that gives you, that makes it a little bit fairer and gives you at least some way to get the client to budge if they are, unreasonably withholding approval. So on that note, we'll go into the next slide here. So getting back to the limitations issue. So this also arises where things for like inspections or observations. Oftentimes it's just going to say, you'll provide construction observation. Well, you should define what that is. How many observations are you going to do? How many inspections are you going to do? Those are all things that should be identified in the contract beforehand to save problems down the road. So an example of that is architect shall review and take appropriate action on all submittals from contractor throughout the duration of the project. Well, that's kind of leaving it again open-ended and is going to probably draw you in much more than it could delay things. It could lead to withholding of payment. A better way to approach this is architect, as part of its basic services, shall provide 2 submittal reviews of each submission by the contractor. Anything beyond 2 submittal reviews shall be compensated as additional services. Again, this is a way to also get you paid and to not only avoid, getting kind of railroaded and sandbagged with all this extra work. Putting these types of provisions or this language in your contract allows you to be able to collect more on, under the contract. So again, and then the last thing is assumptions, exclusions. That's a big one. So if you think that there's issues that could, relate to the project, but they're not included under the scope of services, identify them.
And I'd add in here, my entire career, all I've done is represent architects and engineers. I really respect the profession. When it comes to risk management, architects have one fatal flaw, and it's that you want to help. You're programmed to solve issues. And a lot of times in a situation like this, where you have either a difficult client or a bad contractor that can't build what you designed, your instinct is to help. And, we don't want to dampen that instinct at all. We think it's great. We respect it so much, but we see so often that the contractor points back to it and says, well, no, it was a design change. And, my clients look back at them and say, well, you told us to simplify it because it was too difficult to build. And then, that design change turns into a claim, turns into, an insurance issue, turns into increases in your premiums, all because you were trying to help. So just being aware of that and understanding that some clients and owners and some contractors, not all, but some, don't have the same kind of optimistic outlook on let's all get together, solve the problem, and get this project over the finish line. So just something I like to mention in this point of the presentation.
And again, just from a practical standpoint, don't be afraid to put those types of exclusions and assumptions and limitations in the scope of services. That's something that, related to what Steve just said, is architects sometimes want to be overly helpful and solve problems and, make the client happy. Well, you have more power than you may realize when drafting the contract. And a good time to exercise that is it's totally acceptable to put those types of put that type of language in the contract. The worst they can do is say no, or hey, you propose to limit your inspections to 2, we want 3. Well, if you can live with that, then that's fine. It's not necessarily an all or nothing, but the more you can put that stuff in there, the better, for sure. So kind of rounding this out then, we talked about, one of the objectives is to identify red flags that often come up during projects. So this is what kind of ties all this stuff together. We were talking about this. We identified really 4 main areas. We could make a list of 50, but the 4 main ones that we see all the time that get architects and engineers wrapped up in claims are, and I'm sure you guys know this, construction delays, cost overruns, delayed payment, and just kind of a breakdown of the relationship, especially again in the high-end residential construction, where you're dealing with clients who aren't necessarily experienced in the construction industry and don't necessarily know how things work, and have a lot of money, but also are going to not be open to additional costs that may arise that are just kind of the part and parcel of doing this type of work. So anytime you're on a project and things are kind of coming off the rails as far as construction delays or cost overruns, delayed payment, these are all going to be things where it's not beyond the possibility of seeing a claim down the road. And that's kind of how you should maybe think about it and go about completing the project or moving forward. So the things you can do in that situation, to the extent you're being paid and you're complying with the contract, continue doing the work, paper your file, make sure you're documenting what you're doing, maybe what other people aren't doing. That's also, just as important oftentimes. Communication is key. Sometimes the communication breaks down and that's an issue, but to the extent you can communicate and keep those lines of communications open, that also helps maybe avoid an impasse or avoid things going too far down the wrong path. And maybe this is too legal speaking, but as part of that communication, as part of that documenting what you're doing and papering the file, it's also you want to the extent you can, correct any misunderstandings, if the general contractor or one of the owner's consultants is causing issues that's affecting you and your relationship with the owner or affecting your work, don't be afraid to speak out on those, to defend yourself, and to, that's also part of the resolution process. So you have anything else to add on those areas, Steve?
Yeah, I mean, I think we all kind of recognize, this list could be a lot longer, like Mike said. We all have our own kind of unique risk profile for the different types of projects that we handle. But this is just generally trying to, key you into things that should be, things that should get your antennas up a little bit and thinking about, okay, what do I need to do to navigate this situation? And it's just kind of part of the continuum of risk management that starts, from the day you select a client to the contract you negotiate to, how you handle the project. And then, we're necessarily focused on some of the worst case scenario stuff. But these are just some of those signs. And this slide kind of ties together all of the kind of lessons we hope that you can take away from this, both kind of philosophical and practical. Never guarantee your performance. You're obligated to perform to the standard of care. That's essentially it, and you shouldn't agree to anything more for all the reasons that we've talked about. Provide adequate qualifiers, so have a detailed scope of services. If your client asks you to go outside those scope of services, document it. Things can change, and no one likes to be the squeaky wheel that's always sending confirming emails and things like that. But if the situation dictates it, we want to make sure that you're doing that. Be clear that your role as the architect is to provide options and solutions. It's your client's decision to deviate from your plans, to follow the contractor's recommendation on a value engineering issue. That comes back to documenting concerns to make sure that you're covered in the end. A very basic one, we kind of say it over and over to make sure that if nothing else, you take this away, make sure that your contract either has a standard of care provision that tracks with what we've said, or even we'd prefer it just didn't have a standard of care provision, because the law protects us to a large degree. Manage client expectations. These are all just practice things that we as lawyers, we defer to you on. And then, depending on the size of the firm, your relationship with your insurance broker, your relationship with an attorney, escalate problematic situations so that you can get advice, so that you can put your insurance company on notice if you need to do that. All things that that we help our clients do to make sure that, in the event of a claim, which, some architects are lucky enough to go their whole career without one. Others are not as fortunate. And frankly, having seen hundreds, if not thousands of claims against architects, the performance of the architect during the project is only, the correlation there is limited. So with that, I hope this has been effective. I hope we have some questions, and we will open it up to any questions that have come in, or any questions that you guys might have for us. So thank you.
And if anyone needs a copy of this deck, by all means, just email me or shoot me a text or give me a call. We'll send it over to you. Here's my contact information. We want to be a resource. It's not, if it's often something that we can answer offhand, take 5 minutes. There's really, don't hesitate to give us a call if you have any questions or want more information.
Yeah, absolutely. We like to think of ourselves as a resource for the architectural community. We have relationships with most of the AIA chapters in California, so we're always happy to help out however we can.
Michael and Steven, can you hear me?
And
This is Sam. I'm at Jada. We're a supplier. And as far as managing expectations, we kind of overemphasize lead time. And what I found was effective that during the course of shop drawings, construction talks with the installer and the GC, I'll always reverse engineer our lead time to the date of that conversation in every conversation. So if I have like 6 conversations within a month, I'll always end every email, by the way, 29 weeks from today is, and I'll Google, what is 29 weeks from today, and I'll give them that date. And this is after signed shops, not including backlog. That seems to keep everyone up to speed, and it also creates an aura of immediacy and finality as far as making decisions. But what have you seen? I know your perspective is from what has failed as far as communication, because you're not going to see every glorious conversation and every perfect contract and a perfect project. But what would you recommend, or what has worked before as far as a paper trail of "see, I told you so," as far as expectation of delays?
yeah, well, first and foremost, I really like that example of keeping everyone on task, because I'm sure it's effective on the front end in terms of the immediacy you mentioned, and it's also would be effective on the back end when they complain about lead times and you go to your email that says, well, here it is, 29 weeks from that day was this day, and you didn't make the decision until here. So I like that kind of from a philosophical perspective to come up with ways to keep everyone focused and to kind of cover on the risk management side. I think in terms of what we've seen be effective, specific examples are a little bit tough, but generally it's a willingness to be proactive and to essentially just not assume that everyone's going to agree on what happened in a meeting or what happened, what some decision was made along the way, or even to taking that a step further to correct things that may have been said. I mean, oftentimes we're not the ones keeping the meeting minutes if in an OAC meeting. And so if the contractor is shading things its way or omitting things or putting things that are a court that aren't, effective firms from a risk management perspective are proactive in engaging with that and saying, well, actually, here's what was said. And, or, well, I told you that if you substituted this material out, it was more likely that, you would get water intrusion around these windows. That's a conversation that may or may not have happened, but if there's an email and we get a claim in on a water intrusion and my client says, look, I told them, then I take that to the other side and I say, you're going to dismiss this, or, you're going to lose and we're going to get our attorney's fees from you. So that's just big picture what I've seen.
Gotcha. Just a quick follow-up. We're based out of Grass Valley, California, which is halfway in between Sacramento and North Shore Tahoe. It seems like, and I'm down here in Thousand Oaks, I'm from LA. So it seems like LA has, or the Southern California area has a more liability as far as the potential for lawsuits than it is in Northern California. Maybe this is too much of a generalization or a stereotype, but sometimes my headquarters will see conversations in a project and someone will pop up and go, this is going to be a lawsuit. Let's just step away from this whole project. Do you see is that a general stereotype, or do you work in Northern California too?
I did. So I practiced in the Bay Area for 5 years, and then I've practiced down here for 6 or 7 years. So I've seen both. There's lawsuits everywhere. I mean, there's lawsuits everywhere in California. Some areas of California are more likely to kind of resolve things based on a a handshake and we'll get you next time. That's probably the Grass Valley areas as compared with, West Side LA. But we don't really change our practice in terms of where a project's located, other than to emphasize that there's different standards of care for architects in San Francisco than LA. Just to tie it back to our standard of care presentation.
Thank you very much for your time, though, by the way, Stephen. and Mike.
Sure.
Any other questions? Well, I guess we can wrap it up. Thank you so much for the presentation. Very enlightening and important. And thank you everyone for attending, and we'll see you again soon.
Thanks for having us.
Yeah, thank you very much. We appreciate it.
All right. Bye now.
Take care.
Bye.
Thank you.